All right, we're live. I'm gonna stay off camera for a bit. I am driving actually, coming back from Los Angeles, and then I will be on camera right at about 3:10, and we will keep going from there. But anyways, I got Rachel here. If anyone watches this from the beginning, which I don't even think we have anyone live yet, but if anyone scrolls back, this is Tugboat's office hours. Um, and we'll wait to really get into it until we show some people on here. Typically, people join on Instagram, which is why. Ooh, we're gonna wait. Cody Shaver, the one and
Yeah,
only,
I don't
is
know about
here.
that.
How we doing, Cody?
Living the dream, man. Living the dream.
What is the dream specifically?
I don't know. I'm just doing that just to keep myself like shooting for something.
Fake it till you make it.
What's that?
Fake it till
Fake it till you make it. Yeah.
Yeah. No,
Yeah.
Thank you, guys.
I'll be on camera and on my computer in about a little less than 10 minutes. Cody,
10 minutes.
We'll be normal at that point. I know. I'm driving back from North Hollywood. I had to go out there, and there's some typical Los Angeles midday traffic, you know. Cody, how's your week going? Any depositions? Any courtroom shenanigans you can tell us about?
I have court tomorrow in beautiful San Bernardino, and get to wear a suit. You know, I told my wife, I said I'd wear a suit every day, but I'm too cheap to pay for the dry cleaning. Yeah. So hold on, let me get this so it's.
And it's hot down in San Bernardino. You get sweaty down there in suits. So.
Well, and I think everyone shares a court. Like in Riverside, there's different courthouses. San Bernardino's not like that. So that's fine. I like San Bernardino's my favorite courthouse. People are real.
Why is that?
Real in San Bernardino. Huh? Just real.
I have been. Is that different than Riverside's courthouse? San Bernardino's? Yeah. Okay, I've been to Riverside's before.
Which one? The criminal?
No, it would have been my wife and I did foster care before, and one of our foster children was out of the Riverside network. So wherever family court would have been out of there.
Yeah. So the civil court and the criminal courts, we have 5 courts out here. There's the civil, and then the criminal, family, and bankruptcy, and a federal court.
Okay. Sounds like a lot of crime going on.
Yeah. I'm trying to change his view so that it's landscaped rather than.
Oh, you can't change that. That's on our end. And the reason that we do it this way is only because most people watch it on their phone, so that when they go full screen, they can see all of us a little bit bigger. Or when we show a document and stuff like that. We were streaming it landscape before, but I noticed that most people were watching from Instagram. Well, so alas, and I wish that it kind of let you do both, where it would, if someone was on a phone, they could choose their own layout, but that is not how this works so far.
Well, my wife critiques me every time that I'm on here, so I get random text. Look at the camera. You're leaning too much.
I just got her cell phone number. Since she's your assistant, she's gonna start texting me. Probably that means too, huh?
Yeah, I'm going to start hearing her complain about you now, like everyone else. That Cameron guy, is he not well? Just kidding.
He isn't well. He certainly is not. That's for sure.
Actually,
Cody, a random question before we dive into. I have a couple more claim specific ones, but I was asking about court. I am curious what percentage of cases that you take on. Now you do a decent amount of, call it like pre-litigation work, and a lot of your cases may not make it all the way to trial because you're able to resolve things. But how often, once you are involved on a claim and the carrier has been notified, you're representing, is that claim going to see a courthouse?
You mean an actual trial? Because we go to
No,
court.
not necessarily. No, no, just make it to the point where you're gonna have to go to court,
Yeah.
and start doing that work.
Um, well, it depends. Like a lot of people get me for that purpose, right? To get it out and try and get it resolved. And the best way to get it resolved with me getting involved would be that going to filing, at least with the court. But a very small percentage of mine actually go. Ones that I
Yeah.
get, the people are coming direct. We kind of say it's either retail or wholesale here. When I'm working with public adjusters, which is my preferred method, is working with public adjusters. Well, you guys really, and a few others, not as many, but that's our preferred means, to go with a public adjuster, because then it shows that this insured actually tried everything they could to try and get it resolved. So those ones, maybe 50-50, it just depends on the relationship. Remember, we're in a very large industry, but it's a very small industry at the same time. We run in, and it's changing, Cameron, I'm sure you run into the same people all the time, but that's changing. So a lot of these carriers don't have local adjusters. A lot of them are going independents. A lot of them are just sending out an ES company or a contractor. But it was based off the relationships. That's how, you got things resolved. And if you were just respectful to people and you get files transferred, and such a, the industry changes so fast. It used to be if you got a PA involved, it would go to a special adjuster and they'd work to get it resolved. Then that kind of went to the wayside. And then it was, if it went to an attorney, it went to a certain department and they would try and get it resolved. Some carriers still have that. Allstate sometimes will send it over, and we always get it resolved that way. What it comes down to is somebody who has a time to listen and respect one another. And I'm not saying that they don't respect, this side, but I mean, it works both ways, right? If you show respect, you're going to get it usually. But back on your point, if somebody were to, out of 100 people who call me direct, maybe 30% will actually get filed on. And even that's misleading. So let's take a hypothetical that the insurance company paid 50,000. We think it should be 200. Seems like a fair number. We might get it up to 150, right? And there's still that 50,000. We may file just to get the last bit. Did it have to go that way? No. Sometimes they run us through the gamut or the insured through the whole, we're not paying anymore. We're not going to send out an expert. We're not going to appraisal. I'll get involved to get it into an appraisal. And then afterwards we can show just the conduct. So we'll file on top of it anyway. So it just depends on the circumstances. So when I tell you a percentage, even if it's 50%, that's kind of skewed because of what's the reason we're going, right? Is it because we couldn't get anywhere, or did we get somewhere and we just can't get all the way across the goal line? Or I guess that's not a good analogy either. You cross the goal line or you get something or you don't, right? So, but this one, on this, or did we get everything into the claims process, but we still think that there was some unfair conduct and, what we would call in this area, bad faith conduct, unreasonable conduct. And did that warrant some kind of, hey, you treat these people unfairly. Yes, eventually we got everything that was owed, but, it took 2 years, should that be okay? Right? Should it be okay that they finally, after, 7 adjusters and, 3 experts and, 5 inspections finally pay the claim? Should it just go away? Well, it's always up to the client. What does the client want to do? It's never my decision. I tell them I give them the best legal advice I can. And a lot of times I'll tell them that it's not worth it. It's not worth going, the risk versus the reward, the time, the work on everyone's part. Is it really worth it? And I'm not really here to punish insurance companies, but, I think holding them responsible for unfair conduct is a fair thing to do. So, if you're just talking what percentage of them have to go to litigation because we can't get anywhere, well, I can break it down even better than that. I can say that in today's market, usually if someone calls me and it's a denial, more than likely we're going to have to seek remedy through the court. Usually. It's just the way that the market is. It's just is very difficult. to get people to overturn denials like they used to.
What do you mean like they used to on the denial part of it?
Well, when I was in law school and I was working as a public adjuster, I could tell you for the first probably 7 years that I worked, I never not got a denial overturned. I mean, there was lots of denials that I took on that I looked at and I said, yeah, this is denied. Yeah. See that rot there and see that mold, and see that mold goes 8 feet up the wall, and see how it's all isolated just underneath this cabinet. Or and a lot of it's educating insurers.
Yeah.
Someone called me the other day and they were all upset and talking about the carriers committing fraud and retaliating against them, and it's a really sad story. And it was an assault in the home, battery actually. People use assault; it's actually battery. Physical contact's a battery. And when people say I was assaulted, well, that just means that they gave you the worry that they were going to hit you. So this was a battery, and she was bloody, and as a result, and got blood everywhere. And the big dispute is that there was no coverage for the contents. They said there wasn't coverage for the contents, and when we come down, it's all opinion. I don't think that there is. Contents are a named peril. What's a named peril? Is there a named peril that says if you get punched in the face, you're going to cover your contents if you bleed? And it's sad. It is sad, but I know that there's different opinions on that. People come to me all the time and say, well, if the building portion is covered, then by default, everything else should be covered as well. I don't agree with that. I do think that under certain circumstances, it would be, right?
Yeah.
Like, let's take this, Cameron. Let's take wear and tear, right? A pipe wears out and floods a house.
Mm-hmm.
Are the contents covered? Are the contents covered if they get flooded that results from a worn out pipe? Contents covered? Sometimes they are, sometimes they aren't.
Explain to me where they aren't. I assume you're talking about how it would relate to it being a named peril portion of the policy.
That's exactly what we're talking about. So, but some carriers will cover it and say, or they'll cover it kind of in a way where they say, sorry, client just texted me. I haven't had a text all day, and as soon as I sat down, it's rang like 5 times. Or they'll cover like contents handling, right? Let's say there's different reasons. There are certain circumstances where you say, well, in order to replace this floor to wear and tear, the contents need to be removed, right? Is that paid under the building or is that paid under contents? Well, it's usually paid under building.
Usually.
Correct. My thought is, and this is all opinions. I mean, everyone can differ. That's what's so great of the Bible of the policy, right? Everybody can interpret it differently, right? So, the inventory and the storage, some carriers will say, or people in the industry will say that portion needs to be covered under contents.
Yeah.
Right. That the building portion is just to remove and replace. And then but I've seen them covered all under contents, like the advances that you're seeing for the wildfires, those advances are being paid under contents. Why are they being paid under contents? Do you know why?
Because they don't have to include the mortgage on it.
Yeah. And a lot of people can't figure that out, or they want to argue and stuff. It's actually a good thing, right? That's a good thing. Someone posted the other day, a guy named Armin posted, says it's silly to think that insurance companies hire bad people. Like their interview process says, hey, do you kick cats and pick on little kids? Yeah. Oh, you'd be great, adjuster. I do think, it's all trying to understand. I was talking to an adjuster yesterday, great guy, an absolutely great guy. And it's really funny. I called him and I'm talking to him. He's like, hey, I know who your adjuster is. I got the onboarding. I've spoke about this before when I was talking about, I'm sorry if I'm going off on a rant, on a tangent, I guess it's not a rant. I was saying how they were trained improperly, right? And two people. Well, was that guy? I talked to him yesterday, and I'm just, I was kind of upset with him because I got a client that can't turn on her AC, and it was like 90 degrees. And, he actually was saying, like, I would love to pay this. My hands are tied, and it's frustrating for me too, Cody. I wish I could help you, but here's what I can do. Why don't I write up for everything that I can do? And then she can just use that money to clean her HVAC. I said, why can't you write it up to clean up to clean HVAC? They won't let him write an estimate for anything that is HEPA-vac, right? Anything that has some kind of specialty item. So getting back on track, it's all just about interpretation and what they can do and can't do and versus this. So back on your original question, it just depends on what the facts are. So if somebody's calling me with, hey, I got a denial, can you help out? More than likely that's going to go to litigation. And when I say litigation, it might have a complaint filed, and within a week I get a call from defense saying, hey, can you prove this? Can we send out an expert to go look at it? And it'll get resolved. Because I think that they really want to help. Some of these attorneys want to help, and not all of them. All of them want, pat on the back. Same with me. But back on the interpretation, I argue with people on this side about what should be covered as far as contents, like the scenario I gave you. There's people who say that the whole thing should be covered. I disagree. I disagree that, if the building's an all risk and somebody gets beat in their home, the building portion is covered, but where do we fit the contents at? Where would you think they would fit? I don't think they fit anywhere. It's named peril. What's the peril? But oftentimes we do get coverage for wear and tear from a pipe. It gets some things wet, gets a computer wet, they'll replace a computer. And then I don't ever question it intentionally. I'm like, hey, why are you paying for that? You shouldn't pay for that. I'm just like, but it makes me curious, so it just kind of goes back that, these things are so complicated that everybody's just kind of interpreting them the way best that they know how to do. So, like your original question, yeah, it depends. If it's something like that, where I have to try and argue coverage, then more than likely it's going to go to litigate, at least into the hands of somebody who will analyze it or have the time, right?
Yeah.
I mean, a defense attorney once said to me, and I really like the guy, we're not all enemies. I don't have any enemies. Was it the enemy of my enemy?
I've met some of your enemies out there, Cody. You may not be aware of them, but they're
yeah. They said, you guys on your side, it's always sides, which I hate. They say, you guys think that it's some big collusion with these adjusters and everything. And he says, these adjusters aren't smart enough, nor do they have time to try and run some collusion lies. They're too busy trying to keep up and this and that. And I believe that for the most part, but you might get an easy slam dunk issue, but the adjuster hates your guts. You're right. I do have some people that hate me, and I act all innocent, but it's tongue in cheek and innocent sometimes. But a lot of it's personality conflicts. The fact that you're a PA, some managers will just say, hey, if all PAs are scumbags, and other ones. We've spoken about a friend of mine who's a supervisor. It's on one of yours about the one about was the claim closed or not.
Yep.
She prefers public adjusters on everything.
Mm-hmm.
Depending on the public adjuster, right? I mean, there's some that are really, really bad. So it really comes down to the circumstances. I think that litigation should be your absolute last. Being an attorney should be your last resort, especially going to litigation. So it just depends. Why was I retained? Was I retained because there's a legitimate argument and the insurance company is just saying no? Is there an honest dispute that I can talk to the insurance company? The other day I had one where it went to appraisal, and the public adjuster called me and said, hey, we can't get into pay code upgrades. And I said, well, was it a part of the appraisal? And they said, no, it wasn't part of the appraisal. And I said, well, how do you know that? How do you know? I'm getting like, well, how do you know it wasn't part of the appraisal? He says, well, to answer your question, I have the umpire and both appraisers specifically put a writing together that said code upgrades code wasn't part of the appraisal. So I thought that I would just contact the insurance company and say, hey, look, there's a mistake. It's not a part of appraisal. And I got a one sentence response. Do what you feel you need to do, but we're not going to discuss this with you. So I filed on it, and they called me saying, hey, is this something we can work out? Absolutely. Yeah. So did that need to go? Did it need to go? Yeah.
Let me pay my filing fees to go file a lawsuit.
Yeah. But then on the other side too, I get an unreasonable defense guy when you go to litigation, and they'll say, hey, we're willing to pay hey, sorry this happened, training, whatever, or they won't even apologize. They'll just say, hey, this seems like something we can resolve. Can we just pay the contractual and close it? And I'm always like, yeah, that'd be great. Tell my client. They're like, well, I think they should pay your fees now. And I'm like, I can't guarantee that, So it just depends on, sometimes we get the claim covered and people want to go to litigation. I'll usually reject those though. If they just want to go to litigation because they're angry, you know, I'm not here for moral victories. I'm here for, you know, financial victories to get people's houses fixed. And unfortunately, when you hire an attorney, you know, you're already down behind the 8 ball financially. So, but overall, maybe it's 50-50, 60-40, not going to litigation, but it depends on the circumstances.
Yeah.
So just people calling me, it's probably 30%, 20% maybe. People calling me to try and get claims resolved. Like, because we really, like everybody, what's your favorite claim? An underpaid claim, right? Where coverage has already been established and it's just been underpaid. That's really what we go after and do those at a reduced rate. So a lot of those, no, they don't have to go to litigation, but doing a partnership with people like you, yeah, you guys know how to do your job. So which ones are you giving me? Ones that absolutely have to go. So when you take those into the mix, huh?
Yeah, that's somewhat unique for you. I know plenty of attorneys that would tell homeowners, "Hey, what's the point in hiring a public adjuster? They don't have any authority, right? You're just getting another fee on top of mine. It's going to end up in my hands anyways, right?" So you're unique. You were a public adjuster. You're fine working with public adjusters, but that's not ubiquitous across, you know, first party claims attorneys, plaintiff attorneys.
I think they're invaluable, and not only I'm a big proponent of a case is built in the claims process and who's handling the claims process. If I'm handling the claims process, what does that make me? That makes me a percipient witness, and I get to post, and I don't mind. I always say nobody can explain the egregious conduct of your insurance company client than I can, but in federal court, that creates a problem. Sometimes the judge won't let me be an attorney if I'm so involved in a claim. But that's not really why. I just think, you know, why are we here, right? We're here to provide for our family, I'm sure, but we're here to help people, right? And I don't think having someone call an attorney right off the bat is always the answer. I think if it's a coverage issue, maybe it's something we work in tangent, right? Like I work with you and some of your staff in tangent, and at the PA rate, right? I mean, it's still a little bit more than, I don't know what you guys, because I never really get involved. I just get an email, hey, can you help with this one? You know, sign this client and they'll work with us. Doesn't matter. It's between you guys. You know, I just
we charge 90% at Waypoint Adjusting. There's no fee caps in California yet, so really take advantage of that while we can. No, we're I tell people we're at Waypoint Adjusting, very standard. I would say average, right? We're not the lowest PAs. We've been in the industry a long time, but certainly not anywhere near the highest. We're very much average in our fees.
But you get what you pay for too. You know, I work with a lot of PAs, or I don't work with a lot of PAs anymore, but through my career, I've worked with a lot.
Yeah.
You know, my list of PAs that I won't work with could easily gobble up the list of that I do work with. Because if I'm going to work with a PA, then there's got to be someone that is knowledgeable, can testify, and is there to help the insured, and knows the arguments, right? So there's a handful that I know that I work with, you guys included. There's other people that are, you know, out there that I really respect, but for some reason, there's been an influx of PAs in the last, I don't know, 7 years, 5 years, and you know, they don't do anything. I actually had an attorney with a PA that I do really respect. And I asked him, he was an attorney. And I asked him, I said, well, what did so-and-so actually do for you? And his words were, man, he didn't do crap. And sometimes I'll take that with a grain of salt just because he didn't get it paid, right? It says he didn't do crap. I don't know. That wasn't the term he used. That was my PG version. Yeah. And he really didn't do anything. He did absolutely nothing.
I mean, on pieces of claims, I know other PAs would have other opinions. And well, I want to take a second real fast because Instagram's there has an issue right now where they're not linking to our streaming service. So I have Instagram Live separate on my phone right now. It's just me on there because I can't get it linked to that. So I'll watch the comments there. And then Rachel, keep an eye on the comments if they pop up here for us. For anyone that's here, it looks like there are a handful that are popping in and out. This is Tugboat's office hours. If you're familiar with Tugboat, if you're a user of Tugboat, you know that we are not a public adjusting service and that we help people negotiate their own claims, navigate their own issues, give them expert tools and advice to help them get through whatever scenario they're going through with their claim. When I say we as public adjusters, what I'm talking about is Waypoint Adjusting, which is a subsidiary of Tugboat, and has licensed public adjusters in a few specific states, most notably in California. So a good amount of wildfires being represented there. So, which is where Cody is as well. I want to jump into another question that I had written down for you, Cody, which is, do you think, I know that once a claim goes to an attorney, right, and you're talking to whether it's an adjuster or a supervisor or maybe even an attorney for the opposing, for the insurance company, a lot of time a claim can just turn to what I'll tell people it's like kind of just a straight negotiation. Hey, what number is your client happy with? What number are you comfortable paying with? Right? Like these are how, not that it always gets there, but that's where some settlement discussions get, right? And I've been a part of claim discussions. One of Waypoint's adjusters yesterday told me he was talking with the adjuster on the claim, and the adjuster was like, "Hey, what's the number to get this thing settled and finished?" Right? He's one of the numbers.
Absolutely.
Now, the number on that claim. So I'm going to use that claim as a specific instance, right? There are several different outstanding issues. One has to do with this isn't a claim we've talked about before, Cody, so you won't be familiar with it, but it'll have some recurring themes. One has to do with whether or not the stucco should be painted or should it be, redashed because it's never been painted before. It's a new house in a newer development. The neighbors got redashed a new fog or color coat on theirs because painting stucco, according to people that install stucco, right, reduces its performance. Essentially, it doesn't shed water the same way, doesn't absorb water the same way, and so they're against painting stucco if it hasn't been painted before, right? And so, anyways, some of the houses near the fires that have this issue that's come up have gotten new color coats of stucco. So one of the outstanding issues is painting versus redoing the stucco. And then a handful of other outstanding issues. In total, the number there is about $60,000. When you look at the estimates received for each of those various things, some of it might be regarding contents, but there's an estimate. There's a reason for that $60,000 number, right? It's not something that they drew out of a hat. So that's been submitted to the carrier. The carrier, and that was submitted when it was asked, like, hey, what's your final ask on this claim? And so the public adjuster gathered up all the outstanding estimates that had already been submitted, but really was like, hey, here's everything you haven't paid that the insured and we still believe should be paid. It's $60,000 and change, right? The insurance company responded with a phone call. They paid $26,000 and said, like, hey, is this enough? Like, is this the number that you're looking for? Can we just come to a number, right? And there was a discussion between the policyholder, the public adjuster, kind of talking through, look, are we going to fight for all of these dollars that we think are valid, right? Every one of those $60,000 is valid. It has a reason that it's there. But at what point does it make more sense for a claim to turn into a negotiation, right? Where you're just talking about like, hey, what's a number that we can eventually agree to? Or it's like, no, this number is valid. I don't have any reason that I should be backing down from it. I have all the justification I want for these items I'm asking for. And this is important because this comes up with tugboat users on everyday regular things, right? Where some people are more apt to be like, look, I just want to get moving. I want to get my claim closed. If they give me $10,000 towards my bathroom, I'll be happy. So regardless of whether or not their bathroom should be $15,000, we're just trying to help them get to that number. And where other people do what I think is totally justifiable, like, no, like I'm gonna write down every single thing that was in this bathroom that was destroyed, and I'm gonna put a number on it that's justifiable, and this is what I'm gonna ask for, or I'm gonna demand and stand by it. So kind of where do you land within that conversation, and what would you advise the average homeowner that's going through? And before, I guess, Rachel, do you have any context to add there from the tugboat perspective? You do tugboat claim support on how people view their role of asking their adjuster for something, right? Do they see it as a negotiation they're entering and like, hey, let's find a number we're comfortable with? Or is it like, hey, I'm submitting something to you that you should be paying right now?
They think of it as a ladder. If I have this estimate, then I expect you to pay it. There's no, I mean, they're not going to negotiate with their contractor. And look, sometimes the work is already done. So it's an invoice. That's it. Yeah, no, they don't see it as a negotiation. And I don't either. Me, like as an adjuster, like I'm not an adjuster now, but I've never looked at it as a negotiation. It's either required to restore the loss, or it's not. And if it is,
and
then it's
the last
paid.
context I'll add is we used to have content that we would put out as Tugboat, some of our really early stuff where we would say, like, hey, people should know their claim is a negotiation. And what we were trying to help people understand there was you don't just have to take what's given to you, right? Like you can dispute it and therefore enter into negotiations with your insurance company as far as what should be there. Because a lot of people don't even understand that. They're like, they get a check, it's called undisputed, which sounds really weird. They don't know what that means. And they're like, so I just like, this is what I get now and it's done. And so we were just trying to educate people. We're like, no, it's not done. Like it's a negotiation, go back and talk to them more. But that perspective is problematic. So Cody, I'll let you jump in here.
Well, I agree with Rachel that it's not a negotiation. You should get what you pay for, right? You're paying for a product. You should get what you pay for, which is pre-loss condition. Everything that's damaged or has consequential damage should be included. But at some point, from my perspective, it comes down to what does the client want? Is there a number that the client just wants and they don't care about anything else? What time of the claims process has it been? 2 years? Are we going to keep fighting? Yeah, I agree with Rachel at 100%. You should fight for everything that you're entitled to. You are entitled to it. So it's the same thing we were talking about your friend. He keeps being worried. Are they going to be mad at me? Are they going to be mad at me? And the analogy I used to use is, if you go down and order a Porsche 911, right? It's my favorite car, Porsche 911, and then you go to pick it up and it's a Volkswagen Jetta. Are you going to be like, well, I don't want to say anything. They're kind of mad at me. And yeah, this will get me to work just the same. No, you should get what you paid for. If you want to settle for the Volkswagen, that's fine. But you have to look at it that way. You're paying for a product. This one thing we forget. What's the most important asset of 99.9% of the people out there, right? The most important asset's their home. And they'll take the Volkswagen Jetta for their home. But, a lot of times, I just want to stick on your topic. I do think people should negotiate every line item. And, but if they're getting frustrated at some point, hey, what do you need? But you do see that a lot, Cameron. They walk in, usually an experienced adjuster will walk in and say, what number do we need to get at?
Yeah.
And I'll hold up the estimate and say, this number right here, this number, this is the number we need to get to. And how are we going to get there? How are we going to get there? And I always say, look, I can't negotiate it. I have to fight for what's owed. But I'm not part of the team, and you're not either. You had your friend there on that inspection the other day because he was worried that they were going to get mad, right?
Yeah, he was there. Yeah.
I don't mind having.
No, I don't typically mind. I want them to see that, like, if I'm a public adjuster on a claim, I want them to see that see the work that we're putting in, right? See the expertise that we have to offer. See how we communicate with adjusters. I think we were talking to Rachel this morning about it, and as just internally as a team on Tugboat, like people are so unaware, very understandably so uneducated around what is happening within a claim. We were talking about it in the context of, Rachel, you weren't there. Naomi was there. But around the language that is used in a claim, like people don't even know the words or the meaning of the words that are being communicated, right? So a lot of times I'll want clients to be CC'd or BCC'd on emails, be present for an inspection, sometimes, not always, or maybe even on phone calls, just so they can start to understand what's being talked about. And then I can, this is what it means. So even with that inspection you're talking about, the context of what Cody brought up is there's a friend of mine who has a fire claim. I'm representing him as a public adjuster. And and he's been very nervous about the process. Is the insurance company going to get mad that there is even a public adjuster on it? Are they going to get mad that he's still asking for these things that he thinks that he has a right to, and that the insurance company has an obligation to pay? Just a very accommodating, very kind person, right? And wants to be honest and reasonable. Is what he keeps saying to the insurance company, and is making very reasonable requests. And so after the inspection, I sat with him, and I've done this after every inspection, and just to kind of educate and be like, hey, when the adjuster said this is what that meant, right? And this is the other things they were communicating by saying this. And this is what I meant when I say this, because there's so much, what's the word? Like the words that we use, how we talk about things. There's inside, not jokes, but like just information and how we'll talk about things that are secondhand nature. And I think it's better for homeowners to be as aware of that as they can be, if they want to be. Some people don't want anything to do with it at all.
So you mean your client wouldn't understand if you were talking to the adjuster and you said, well, my client's going to use his LOU coverage for ALE and also for LOR for bedroom number 2. He'll sign an SOL as long as you don't send out an ROR.
Exactly.
Yeah. You know, there was a legal thing that said that these policies are so complex that there's no duty to read because they're so complex that the average person doesn't.
I've seen that before, which is it's kind of wild to me on its face.
Because I was talking to someone today, they came by and I said, we're talking about, you don't realize how long we've been doing this and things that come second nature for us, you know, like just coverage and all this other stuff, and have to step back. And like, he trains people and he gets frustrated. And I'm like, yeah, but right, you've been doing this for 30 years, like 20 something years. Yeah. So, but he's a little frustrated. But same with the adjusters, you know, we have to train the adjusters, and I don't mind, you know, for a long time in my career, adjusters would call me and ask me for opinions. Like, oh, can I get your opinion on this? I'm like, yeah, that'd be great. But that doesn't happen anymore. And they've kind of taken away the camaraderie in the industry where, you know, you'd go out and meet the same people and you become friends. You know, I mean, I've hung out with people and seen people at weddings of friends and everything else, and go, hey, I know you, and you don't even see them. I don't, you know, almost like these adjusters are AI, right? Little chatbots now, but yeah, you just see them all the time.
Yeah, you're into the same ones. And I've only been in the industry for 8-9 years. And it's shifted so much since then, even, right? When I was an independent adjuster, there was a handful of public adjusters that I would see on claims, and I would see them repeatedly as I worked in Southern California. So yeah, it kind of went both ways. And
I was on a job today, and the insured said, I was on an appraisal. The client hired me to do an appraisal. And she says, I had a loss with them 8 years ago and it went so smooth. And I go, yeah, 8 years ago, most of them went smooth. Yeah. And it was the most cut dry case. It was 1969 or 79 cap, old growth, right? And you're not going to match it. The face frames are gone. Wood floor, parquet, glued down over. I mean, they were getting it up without affecting the subfloor. Cut and dry. They could not come to a decision. You wouldn't see a dispute like that 8 years ago, 7 years ago. You'd go in there and even bring in an expert. And even the other appraiser was saying how most of his appraisals now that he gets, they don't even have expert estimates from the carrier to go off of.
Yeah. I have a feeling, and Rachel, you can maybe speak to some of this too with your experience with larger carriers, but that the hesitancy to say yes to things comes from a concern for setting any type of precedent on any claim, right? So the flexibility ends up being gone, right? On the stucco issue that I was telling you about, on my friend's claim, on the testing issue on that same claim, and on so many others, right, where they don't want to pay for the testing. On so many of these issues, we know that, say we have to call you and you start working on the claim and you get a white waiver and work with the other attorney, it's almost like it's going to be an easy yes once it gets to that point. But is it only an easy yes because now it got hidden behind a white waiver and a release? on the other side, right? Now, no precedent is ever going to get set from this. So even though it's these small things, we feel like, right? Like, why
And
are
we-
we spending so much time? What's
just
that?
I didn't mean to cut you off, but I did actually
You're
cut
good.
you off.
No, keep going. You're good.
We sign a settlement, right? Confidentiality.
Yeah, exactly. That's what the release is, right? When after a white waiver,
Yeah, I
when
missed.
it's agreed to.
But the white waiver means that everything we talk about is confidential.
Yeah,
Then the release says that this is confidential.
Yeah.
So we get a lot of things resolved through a
confidentiality. Yeah, and which
But-
again to me signals they don't want to set any precedent, and that's the concern that seems to be like it's there.
But you're right. I had an adjuster at a carrier, and she was a mid-law supervisor, was trying to settle a case with me, and her manager specifically said, because she was open with me, said they won't settle it because they don't want to set precedent. I go, well, then let's go under white waiver. They said it doesn't matter. I go, it does matter, 100%.
Yeah, it matters a lot. It matters a lot. But and the unfortunate thing about that, like a homeowner doesn't get to enter white waiver with their adjuster without representation, right? They don't get the benefit of getting to do that.
Do they even know what it is?
No.
No.
I didn't know what a white waiver was until an attorney told me when I was a public adjuster at some point, right?
White v. Western, yeah.
So unfair
The,
to standard everyday policyholders. It makes me sick. Just sick.
Yeah, so I want to let's transition there. We have a little bit of time left to think through. So much of the chatting that Rachel and I do throughout the day and the week is, hey, a new problem came up. Let's strategize. What's another angle we can take with this, right? So this seems like a pretty ubiquitous issue across the industry where it's like, man, these small things that used to get a yes, maybe through some back and forth, maybe it took the homeowner or a public adjuster, are just getting a really hard no at this point, right? Like a very hard no, which means an attorney has to get involved, right? And you have to. I've gotten a white waiver as a public adjuster before, so that does happen. But needing your representation. So what comes to mind to me right now is that if a homeowner's in that situation where they feel like this adjuster just doesn't want to say yes, and we're able to tell them like, look, it seems like maybe they don't want to set a precedent by saying yes to this roof issue or this stucco issue, whatever it might be. I wonder if there's a way that you can explain to the adjuster that this is somehow unique. Therefore, no one will there is going to be no precedent set because of this. Because let's talk about how my claim is unique to all the other claims, even though it likely isn't, right? But if you need to help your adjuster get across that, it's not beneficial to us because honestly, as public adjusters, I love using precedent, right? No, you said yes to this before on this last claim. I'm going to show you where you said yes to this. I am not above using that if I can. But what I'm mostly for is every individual homeowner needs to get through their claim and get through the stress of it and try and get to a yes on things that are reasonable. And so if there's a way of doing that is, hey, let's talk about how my claim's unique, right? This is why my roof is different than the other roofs that might be there. And just make sure that you put that in the coverage letter, right? We covered this because of this unique issue. And now the next roof that comes up you don't have to say yes to that one. They can have their own arguments. Whatever.
Yeah. That makes sense, but that would take some training that they just don't do anymore, right?
Having a good adjuster on the other side.
Well, I think that not only the training that was invaluable, but working in an office and being able to ask associates questions because everybody runs it. They don't have that anymore. Yeah, they got some IM thing or something, but you work from home, Rachel. How did you find you had to do it yourself? You don't have anybody you could ask. Right?
Well, yeah, at the other end of Teams, right? But Google is my best friend. Like it was for a very long time because I'm just special in that way. I'm a unicorn. I will not stop until I know every single thing about it. Like I know more about smoke damage now than I ever thought. Actually, I've forgotten stuff now because I've learned so much about it because I've never done smoke damage before.
Yeah.
This is a whole new world, and I feel like I know a lot, but it's because I try. I go to all the resources, and it wasn't carrier training. Nothing I had was carrier training. Nothing.
Adjuster, the job of an adjuster, it's not different than, I can think of a dozen other jobs that are similar in that you will rise to the level that you decide to get to, right? You could go work at a restaurant for I worked at a restaurant as a kid in high school, and like was a takeout and a server from the time I was like 16 to 18 or 15 to 18, right? I didn't learn what it was like to manage a restaurant or cook at a restaurant, really. I served food and tried to get tips, right? But if I decided like, hey, I'm going to take this job really seriously, I want to know what it really, like how a restaurant works and why we're serving the food we are. What are we trying to do here? Which an adjuster is a job that someone should have that posture, right? It's you have this fiduciary duty to the insurer. You have a modified fiduciary duty to the insured, or none, according to guys like Stephen Badger.
They call it in court a special relationship.
There you go. You have a special relationship. Like it is a unique job that I don't think someone should consider the same way they might being a cashier somewhere, right? But again, at any job, you can decide like, hey, I want to really understand why I'm doing this, what's going on here, how I can do it better. But there are people. So Rachel, you've been an adjuster for 5 years, right? A licensed adjuster.
Yeah, 6, but yeah.
Cody, you've talked with Rachel enough that you can attest to like, oh, Rachel knows more about claims and coverage and policies than many 10 plus year adjusters that you've dealt with, or 20-year adjusters, right? Because you can be in that job for that long and just follow whatever estimating guidelines there are, and really never have to dive into what is smoke damage, what does it mean, what's the little bit of science that's available that's around it. Like, it doesn't take forever. It's not like it's not going back to college, but it does take some effort.
You know, when I was an IA, I will tell you this, and this was a very small IA firm, and I'm not saying this is the norm, but when I was this was, I don't know, 15 years ago, more. They would tell me wildfires weren't a big deal back then. They weren't. You know, they just, like when my father in the 80s got a DUI, it wasn't a big deal, right? So it's just weird. And you still had people that would chase it, and they were just starting to get hygienists out, and they would say focus on, now 15 years ago, a lot more people smoked. They would focus on fireplaces and smokers, and they would tell us take pictures of the ashtrays and stuff. And back then it was kind of like, well, that makes sense. Oh, you're going to complain. This is just the mentality, it's the way they present it. I was speaking to an adjuster one day, and I said, how is it that you can get one expert who will agree with us, and then another, sometimes you get an experts and they just shoot down everything that we say. And the adjuster, large loss commercial adjuster, a GA, said it's all in how we ask them. If we say, hey, there's a PA here, you know, hey, can you go out there and just listen to them and write a fair report? Or, right, hey, I got this punk PA on this thing. Can you just show them what's up? It's all how they ask. So back on that, they would train us and say, you know, yeah, these people are making these smoke claims, but they smoke and they got fireplaces. You're like, yeah, why would they? Well, yeah, what the hell? You know, you get all irritated about it. And you're like, yeah, there's a picture of an ashtray. Oh, look, there's a cigarette butt, you know, outside. And so a lot of this thing and how they train people and the smoke claims was, and it might be a little off subject, it's how they present it, right? How they tell them. You know, people say, oh, do they tell people to deny this and shoot this down? But they might not, but the way that they train people. So they're looking at a different perspective than you, Rachel, how you looked at it, saying, you know, really looking into it. These adjusters are being told, because they don't have the time. Let's admit that a company adjuster doesn't have the time to sit and do research like you might do. You know, maybe you did, because you did when you were doing fences, right? You did. But you took it upon
65
yourself.
claims at a time. That's a lot.
See, that is a lot. And the most adjusters are there. They have lives. I'm not saying you don't have a life, Rachel. I'm not saying you're a loser, but they have life, right? It's just a job to them, and they're just doing exactly what they're told. They don't have the time to research.
It's just a job. That's the key thing there.
Yeah.
It's not.
So like me, when I was an IA, I was going to school. I didn't have time. My managers would explain to me going, don't you think it's funny that people are making this claim for all this, you know, alleged smoke ash and ash, but they're smoking cigarettes and have a fireplace and have a coal burning barbecue out back? You know, that's the stuff you need to focus on in case this goes litigation. And I was like, yeah, you're right. But then I start looking at stuff on my own going, well, hey, this is burning lead. This is burning asbestos. This is burning, you know, hey, this is toxic. So yeah, not that they're cigarettes or not, but anyways, I think it's that's a lot of how they approach these things.
Yeah.
Yeah.
I don't know. I know I get off tangents.
No, it's
Perfect.
just chat.
We were talking the other day though, and just we got a few minutes. Aaron said that was a good. Like, we were talking about something, and Aaron says that's a great
It's
topic
so funny.
for office time.
He and I was like, "What did you tell Cody was a good topic? Did anybody write it down?" And I could not remember.
I can't remember either. And I thought
we gotta
oh,
have someone else present to write these things down. It's gonna pop back in my mind.
You recorded it.
Yeah, I did. Yeah, actually, let me double check. I can actually see the notes.
You recorded it because Aaron's like, yeah, that's a really good topic for office time.
Let's see what I got here. If I can find it for this last 10 minutes.
Last few minutes,
Here's the meeting.
I think, but the topic of today seemed to be, should you negotiate or should you fight for everything? You should always start off fighting for everything, but at some point you're going to get worn down, and especially if you're in a place where you can't stay in your home. I have a client in Pasadena that can't turn on her AC because it's full of lead dust, and I'm just like, look, let's just get your AC cleaned and move on. And it's just funny how the carrier was just systematically just dropping everything. Standards change, boom, we're going to change it. So when it's all said and done, she's not getting her house cleaned. She's getting the ductwork cleaned, but it came under the threshold inside the house. It's just crazy. But then on the other hand, she got paid for a fire before and has no proof that she had hired anybody to get it cleaned the first time. And I was fighting for a roof. Remember the roof I was telling you I was fighting for? That's the one that I was saying these two adjusters were trained wrong. She'd already been paid for her roof. So you always have problems on both sides, right? So I think someone has a
Emily, I talk to her every week. She's just worn down. That's what it is. I think they want, I do think sometimes adjusters want that. They just want you to go away.
I don't think it's to your point though, Rachel. It's saying an adjuster wants somebody worn down. That can be almost, because I'm thinking back to when I was an independent adjuster. Like, what did I want? I wanted a claim closed, right? And so, even my personality type, like if I'm naturally a procrastinator and things like that, right? And so issues can build up, and a claim that has these long tail of issues is overwhelming, right? It's just all these things, and so you kind of just hope, like, well, I'll ignore it. Hopefully, they just stop asking me about it, and then it goes away. Because if they stop asking for it, then I don't have to deal with it, right? So it's almost just this idea, I think, for a lot of adjusters, because you had 65 claims on your plate at a time. I had as many at a time as an independent adjuster with several different carriers. And it's just, I don't want to have to constantly come back and think about this. So I'm just going to not for a while. And the result of that is someone's going to get worn down. Emily says when it takes a week for the adjuster to respond to a question, it creates a lot more anxiety, which absolutely makes sense. Absolutely makes sense. And we talk about it all the time, that the most common issue that somebody has in their claim is or miscommunication from their adjuster, right? They're not answering, they're not responding. The problem is they have 2 weeks to respond at all, right, Cody? Like, they cannot respond to your email for a full 2 weeks and they haven't done anything wrong, right? They're not even acknowledging that it came in, right? Yeah. And then that email 2 weeks from now, which it so often is, can just say, we received your email, we're reviewing it, and we'll get back to you in a couple of weeks, right? Like, then you're like, wait.
We'll get back to you within the 40 days allotted per 2695. What is it?
Exactly. So it's like, wait, they actually have 40 days to respond to your email, not to respond to the question you asked.
A response in 15 can be exactly what you said. We've received your email and it's under review.
Yeah.
But one good thing is that I will say, the Department of Insurance, if you write them and file complaints, it does go to management and you will get a response.
Yeah.
I'm not finding that for every one of ours.
Really? They're not getting a response? Oh, wow. That would be new. Because that was the one solution before, is it took a month, but if you filed a complaint, you would at least get a response from a manager about a month from now.
One of the DOI responses we have that was forwarded to us to review is, you need to talk to your adjuster about this. Boom, done.
Really?
I promise.
Wow, the DOI in California must be really overwhelmed. Cody, I found the topic. We can save it for next week because we only have 5 minutes, but we can tease it if it makes sense, which is you were talking about recording inspections and whether or not it's legal and what the effect of that might be, which is different than recording a phone call. But I'll ask this for the average homeowner, right, that doesn't have a public adjuster. We can kind of end on this one. And Emily, we're there with you. We'll remain with you. I know you lean on Tugboat support really heavily. I encourage you to keep doing that. Whatever you can to stay motivated to continue fighting on your claim, like to not get burnt out, even if it's to step away from it for a little bit, right? And understand that, hey, I can come back to some of these arguments later. If I'm moving back in and they haven't paid this full invoice, I cannot ask you that you cannot engage with them for a couple of weeks and take a break and come back with a fresh perspective as well. I know that's not an easy answer, but real fast, Cody, the last thing we can end on is for the average homeowner, if they have a phone call with their adjuster, is it a good idea generally for them to tell the adjuster, hey, I'm going to record this phone call for my own notes and my own records? How do you think that's generally received? I know like legally it's a wise thing, right? To have a record. I know that when I tell an adjuster that, sometimes they'll tell me I can't record it, which is wrong. Sometimes they'll stop talking altogether and just hang up because they don't want to be recorded. Sometimes they'll just change the whole tone, right? And it'll become a very non-answering conversation. And sometimes they'll act very normal, right? Like, but it's the whole gamut of it from like, you can't record me. They'll just hang up or they'll change what they're saying, or they'll be totally normal. So for a homeowner, are they going to get that same response from their adjuster, you think?
Yes, but in lower percentages of the negative, right? There's nothing in the policy that says that they can't be recorded. There was one in Florida that I saw that did say they can't record it. As far as California, there's nothing in the policy that says. I used to get in this all the time when I was a public adjuster. I'd record everything, and I would always tell them that I'm recording it, and they would try and say no, and then I would just keep on them saying, show me the policy where it says I can't record this. Yeah. I know there's some people that'll try and bamboozle. I know that some people, we're talking about on the phone, but what they'll do is they'll hold a pad of paper with a recorder and say, hey, does anyone mind if I, document this, but point to the paper to make it misleading because they have a recorder underneath, and it makes it look like, I'm just going to take notes, right? So, but here's
I'll tell you the sneaky way to record a phone call with a carrier that I've been informed by an attorney, and I would tell a homeowner doing a heartbeat, is to call the carrier, the 1-800 number, for instance, which for vast majority of carriers, it will tell you that the phone call is being recorded. And so it will inform you that the message is being recorded. And then if that carrier has a system for transferring that call to the adjuster, that adjuster, it might be transferred to their cell phone. Most likely it is, right? But they are not going to get re-informed. Their guard will be down and they will not realize that it's a recorded phone call, even though the carrier informed you, so you can record it at that point. I've never seen that disputed in court. I have admittedly practiced that myself as a public adjuster to get a recorded phone call. But I haven't ever had to bring one of those phone calls into evidence and try and submit it and be like, hey, here's a recorded phone call. And I assume the carrier might be like, no, he never asked permission to record this phone call. Do they have legal permission? I would assume so at that point.
Well, all they have to do is be notified, and they're notified by their company recording it.
Yeah.
Once there's notified that it could be recorded, right, then that's disclosure, and that's consent by both people staying on the line. So by both people staying on the line, knowing that the company said that we're going to record this phone call gives you permission to record it because it's about consent. You both stayed on the line, which means you both consented to being recorded and having this disclosed to a third party.
Yep.
So, yeah, I think people should record everything and be honest about it. And if they say anything about it, show me the policy. That was my argument all the time. Yeah. And I had attorneys call me and send me letters saying, we want copies of every recording that you ever did. I hid it in the language of my boilerplate letter, my notice of representation. It was like paragraph 5, sentence 3, just out of the blue, And
that was your pork that you added into your bill.
Yeah, and I would record everything, and I used to carry a recorder, and then I used to carry my phone like this in my pocket, and it just sits perfect just to record everything. And I'd say, hey, look, it's disclosed right there that all inspections will be recorded. I used to carry signs and put them up at my client's house. It says audio and video surveillance at all times. Take a picture of the adjuster walking in. Yeah.
We're at the hour, so we'll save some of this. I think it's a good topic to maybe dive into a little bit more next week. We'll have plenty more.
I'll be here.
Cody, stay on for a second. I had a couple questions to go over as we get off the live channel. But for anyone that's still here, thanks for joining. Then we do these office hours every Wednesday. We're trying to get more of Tugboat's users in here to dive into some of their stuff. So we're finding out ways to keep them notified that this is happening. And if you have any questions, send them to us so we can make sure that we cover them during this hour with Cody, with other public adjusters that join us, and get your questions answered. All right. Thanks, everybody.
Thank you.
Bye.